So far, there's been mixed reaction following that decision by the Constitutional Court to dismiss the rescission application by the former president. The Apex Court's judgment, handed down by Justice Sisi Khampepe, whom you've just seen, found that Zuma did not qualify for a rescission and sought to reopen the merits of the contempt proceedings, which had already been disposed of, it said. The court also awarded a cost order against Zuma. This was the order made in the majority judgment. Advocate Modidima Mannya is a legal analyst and political or public commentator, and he joins us now. Very good evening to you, Advocate, and thank you so much for speaking to us. First of all, let's start with the big English litigious skullduggery, just to bring it down to layman's terms. I'd imagine it's more about the dishonesty aspect of it. What in particular led the court to make or to characterize its finding in this way?
Good evening, Tsepis and your viewers. I think the court was on fire today. Not only do they refer to skullduggery, which borders on dishonesty, so they basically saying he was dishonest in challenging this order because it was meant purely to avoid going to jail. But the court also uses harsh words against members of the court. For instance, they said the second judgment is misguided to rely on international law. They described Mr. Zuma as blowing hot and cold, and they referred to creative attempts to have the order set aside. So the court was appeared to be very firm today, and harsh words were used in that judgment.
But there were also two dissenting justices, Justice Leona Theron and Justice Chris Jafta. What are your thoughts on their finding that Zuma's imprisonment should be dismissed as the correct procedures were not followed and Zuma did not have the right to appeal, as would have been the procedure in a criminal trial? We've had this case or this argument before about the differences.
Well, firstly, it's important to point out that the court remains divided, with the two judges sticking to their guns and the majority sticking to their guns. But I think there's something pointed which may be disturbing with regard to the second judgment, the minority judgment, is the view that the two judges hold that the covenant applies. Now, as the majority has found, such instruments only have legal effect externally unless they are accompanied by an implementation act, which means that Parliament ought to have done a formal ratification. So this is why the majority says this does not have any compelling effect here on the South African courts because there's no implementation act for them. And I think it might be a matter of concern how the two judges missed that basic principle. And I think this is why probably, although I may not agree with the language used, but that's probably why the court described their reasoning in that regard as misguided. The second issue is that the majority says, we have afforded Mr. Zuma his procedural rights. But I think one must correct, because there's a perception that this case was about Mr. Zuma's failure to appear before the commission. It was not. This case was about an order of this court directing him to appear, which he failed to. So the court was exercising and vindicating its authority to make sure that its own orders are complied with. I think the debate about whether his right to appeal or not right to appeal, I think it's become a bit academic. The court has said that its judgments and orders are final and are immune from appeal.
So Justice Khampepe is saying that Zuma's argument that he did not participate in the process which led to his jailing does not hold water, that it's not true. So focus the argument for us. The rescission order, was it not against the process and procedure followed by the court? And I want to go back to the issue of a criminal trial, which is something that was echoed many at times to justify why the former president ought not to be imprisoned. You'd remember several times it was said that he was being imprisoned without trial. So is there a difference in interpretation of the law, or is it the process that was followed or not followed?
Yes, I think there's a big distinction between a normal criminal trial and this type of process which was followed in this case. We have got sort of three types of approaches to matters here. We have what we call actions, where I'm suing Tsepiso for the 50 rands that she owes me. I issue a summons and all these kind of things. Then we have got what we call motion proceedings, which is an application where the court decides on matters based on the documents before it. So there's no like Tsepiso will be called to take a stand. It's in highly exceptional circumstances that happens. Now, in a criminal trial, you are charged, a complaint is made against you that Tsepiso did this, the statement is taken, the police open a docket, take it to the prosecutor, you are brought to court, you apply for bail, you go through a trial in the normal course. This is not what this procedure in the constitutional court involved. This was what I've described as the motion process, where the commission made an application, firstly, to compel Mr. Zuma to cooperate and appear before it. The court considered that and made an order that Mr. Zuma must go and appear. Mr. Zuma then decided he's not going to appear. The commission went back to say, you made this order, which is a valid order. He has not complied with it and or has defied it. We want you to sanction him. So they then requested the court to sanction him, and the contempt application was about sanctioning him for not complying with the court order. Okay. So the procedure of the criminal trial doesn't apply here.
You mentioned this earlier on. The spokesperson for the Jacob Zuma Foundation, Adv Mannya, said the ruling was disappointing and would shake international confidence in South Africa. And he cited the relevance of the UN International Covenant on Civil and Political Rights, which sets out a number of rights of accused and arrested people. But Justice Khampepe in this case said it is not applicable to South Africa's legal landscape. Why is that? And are we a signatory to such? Where does it begin and end?
Well, firstly, former President Zuma must be described correctly as a contemner as opposed to being an accused in a criminal trial. I think the continued obfuscation of trying to suggest that he's going through a criminal process is misguided. Secondly, South Africa is a signatory to a number of conventions, international conventions. But in law and in terms of our constitution, the effect of those conventions inside South Africa take place when our parliament passes a law to give them legal effect. So any convention or instrument which the Republic of South Africa has assented to or is a signatory to, which doesn't have what we call an implementation act, that is where Parliament has passed a law to give it legal effect in South Africa, it's not really binding on the courts in South Africa. It is, of course, of external effect, which means you can go to an external body outside of the Republic to exercise whatever rights there are.
Thank you so much for sharing your insights into these issues. Thank you so much, Advocate Modidima Mannya, legal analyst and public commentator, and we'll continue getting your thoughts on this particular issue. It is our question of the day. Varied responses to the Apex Court's decision, so more from our viewers and various commentators later on.